letters patent, no Governor-General could possibly claim to have valid legal authority, because the Queen of Australia simply doesn't have authority to issue letters patent, and give them their commission too, of course, but just does not have that authority. Now, it gets more interesting though. The Governor-General, it states here, before assuming office, a person appointed to be Governor-General shall take the oath of affirmation of allegiance and the oath of affirmation of office in the presence of the Chief Justice or another Justice of the High Court. So the Governor-General has to swear an oath. And on the last page of this letters patent, and letters patent by the way is letters of instructions to the Governor-General, it states, for the purposes of these letters patent, a reference to the oath or affirmation of allegiance is a reference to the oath or affirmation in accordance with the form set out in the schedule to the Constitution of the Commonwealth of Australia. So there you go. He has to also swear that same oath that the politicians swear, and I'll just run through it very quickly again. I, his name, do swear that I will be faithful and bear true allegiance to Her Majesty Queen Victoria, her heirs and successors according to law, so help me God. And as we said before, the note says that it would now read the Queen Elizabeth II, but it is crystal clear here in the note that it is to the King or Queen of the United Kingdom of Great Britain and Ireland. So there again you have letters patent issued by the Queen of Australia, the title created in 1973, but he is swearing allegiance to the Queen of the United Kingdom. I believe another mistake. Here we have the Australia Act, which was passed in 1986, and that was referred to in the Heather Hill case, you may remember, where they said we're certainly an independent sovereign nation after this Act. Well, we were much before that, and even the High Court judges will admit that, but now you can argue as to the validity of the 1986 Act, and with good reason. However, the fact is that it is passed through the Parliament, it has had royal assent, and whether we like it or not, it is law. And the first clause of this Act says, an Act to bring constitutional arrangements affecting the Commonwealth and the States into conformity with the status of the Commonwealth of Australia as a sovereign, independent and federal nation. So, as the judges said, clearly after this Act, we are a sovereign, independent federal nation. However, in Newcastle, in December 2002, there was a court case at the District Court, and the District Court judge made this statement. Now, I hear what you say about the Queen of Australia as opposed to the Queen of the United Kingdom. Bear in mind that we are still a colony, effectively a colony of the United Kingdom. We still do not have a separate sovereign nation. So that's in December 2002, several years after the Australia Act was passed. So it would appear that we even have judges who aren't aware of whether we are an independent sovereign nation or a colony. I think you can probably start to see by now that Australia is a legal basket case. Now, I wrote to the Attorney General and I asked him if the Magna Carta and the Bill of Rights still applied in Australian law. And he wrote back and he said, the statutory enactments of Magna Carta and the Bill of Rights were received by the Australian colonies and may therefore have a continuing application as part of the law of Australia. However, that application may vary between Australian jurisdictions, and of course that is state and federal parliaments, to the extent that the enactments continue as part of the law of Australia. They may be amended or repealed by the relevant Australian legislature. So he's saying that the state or federal parliaments can amend or repeal the Bill of Rights and the Magna Carta. I find that a fairly astounding sort of a statement. However, you'll see that that is totally supported by the High Court. Now here we have Bryant versus the Commonwealth of Australia in 2002. Joe Bryant took this case to the High Court and he argued exactly that same thing, that he believed the Magna Carta and the Bill of Rights should still apply in Australian law, given that our constitution is British law, and he did a pretty good job of arguing it too. However, Judge McHugh, when referring to the Bill of Rights and Magna Carta, said this: "Those rights that you assert, unfortunately from your point of view, just did not exist after the Constitution came into force, except insofar as the Parliaments of the Commonwealth and the States allowed them to continue in force. But if they wanted to change them, they were at liberty to do it. That is the whole purpose of our Constitution, to change laws." So there again you have the High Court stating that the states and federal parliaments could change the Magna Carta and Bill of Rights. They were at liberty to do it. Exactly what the Attorney General said to us. Now, I've got another High Court case. This is Essenberg versus the Queen. This was in the year 2000. Similar argument. There are more, but I think two cases are enough to prove the point. And similar argument about the Magna Carta and the Bill of Rights. And the judge said the following: "But is not the problem you face that Magna Carta and the Bill of Rights of 1688 are not documents binding on Australian legislatures in the way the Constitution is binding on these legislatures? Any legislature acting within the powers allotted to it by the Constitution is entitled to legislate in total disregard of the Magna Carta and the Bill of Rights." So there you are. He's saying that they can legislate in total disregard of the Magna Carta and the Bill of Rights. So clearly the High Court is virtually telling you that they just do not apply at all. And in that same case, Essenberg versus the Queen, the judge went on to make this statement: "But Parliament, some authorities would regard it as regrettable, can in effect do it as it likes. It is said some authorities could legislate to have every blue-eyed baby killed if it wanted to." Now that's a statement from a High Court judge. That makes you wonder where we're going. All right, I wrote to the Attorney General again, and I said to him that it's my understanding that if we are an independent sovereign nation, it's my understanding that we, the people, are sovereign. And he wrote back, and this is Philip Ruddock, and it's actually signed by Philip Ruddock, which is pretty unusual. And at the end he said this: "You may, however, be interested in some observations of the current Chief Justice of Australia, the Honourable Murray Gleeson, AC, in a recent publication, The Rule of Law and the Constitution, ABC Books 2000. The Chief Justice states at page 6, the sovereignty of our nation lies with the people, both as a matter of legal principle and as a matter of practical reality." So that's the Chief Justice of the High Court. You can't go too much higher than that. And he is saying that we are sovereign as a matter of legal principle and practical reality. However, if you go into a Queensland court, I can't say what the other states are, what their legislation and so on is, but this is what a Queensland police officer swears as his oath: that I will